Before a single word is spoken in this courtroom, the weight of what's coming is already overwhelming. A jury has delivered its verdict, and today, Jeffrey Pennington faces sentencing for sexual conduct with a minor under the age of 12, one of the most serious crimes under Arizona law. Prosecutors say this case is about accountability, protection, and irreversible harm. The defense signals an appeal. Parents sit quietly in the gallery, and the judge now holds the power to decide whether this sentence will simply punish or permanently remove a threat. Stay with us, because what unfolds next is as devastating as it is final.
I filed an active secondary case.
Okay, and that's in Division 1, so that case is no longer active?
Correct.
Okay.
Then we filed a notice of appeal.
I'll note for the record that the court has reviewed the pre-sentence report that's dated December 30th by Officer Smith. Mr. Pennington, can you please tell me your full true name, sir?
Sure, Jeffrey Thomas Pennington.
And is he picking up, Madam Clerk? Do we need to move the microphone? What's your date of birth, sir?
70.
Okay, thank you. Based upon a jury finding, it is the judgment of the courts that you're guilty of count 1, sexual conduct with a minor, a dangerous crime against a child, the victim being under the age of 12, committed between January 1st of 2018 and January 1st of 2020, a Class 2, non-dangerous, non-repetitive.
This moment is critical to understand. The judge is formally entering judgment based on a jury conviction, not a plea deal. That means the facts were tested at trial and found proven beyond a reasonable doubt. The charge, sexual conduct with a minor under 12, falls under Arizona's Dangerous Crimes Against Children statute, which carries mandatory sentencing consequences. There is no probation option here. The law presumes severe punishment because of the age of the victim and the long-term harm these crimes cause. This isn't about discretion anymore. It's about statutory obligation. Knowing that, ask yourself, what kind of sentence could ever be enough in a case like this?
Expressed any remorse towards the victim. He has never once shown an ounce of empathy or sympathy for the harm that he caused her. He doesn't care. The only care he has ever expressed was for himself. The only things that he has done in this case was declare that he was uncomfortable in the jail, complain about his treatment for his cancer, discuss how he was scratching and making himself bleed. The only person he has ever cared about was himself. And I am positive he will claim that his cancer is a mitigating factor in this case. That this errant coating in his cells that has made them multiply out of control somehow should make his sentence lesser. While Arizona law does not force you to find some sort of causal connection between mitigating factors in his sentence, it does allow you to assign weight if there is no causal connection. So if you somehow find some pity in your heart for his condition, I ask that you give that minimal weight, considering that has no causal connection with his crime.
What you're hearing from the prosecutor isn't just emotional, it's strategic. She's systematically eliminating every possible mitigating factor the defense might rely on. No remorse, no accountability, no acceptance of responsibility. Even serious illness, like cancer, is addressed head-on, with the state arguing there is no causal connection between his condition and his crimes. This matters because judges are allowed to weigh mitigation, but only when it meaningfully explains or reduces culpability. Hey, the state argues the opposite, that a defendant's lack of empathy makes him more dangerous. Do you think remorse should matter at sentencing, or should the harm alone decide the outcome?
Despite all that pain and all that suffering that she continues to go through to this day, she still testified, refusing to suffer in silence any longer. And it was one of the bravest things I have ever witnessed, because up until she actually testified, we were unsure if this would be the right thing to do, if she would be able mentally to come up here and do this, or if we were doing more harm to her than good.
This is one of the heaviest portions of the entire hearing. The prosecutor isn't speaking hypothetically. She's describing the lived reality of a child who was 7 years old when the abuse occurred. A child who later became suicidal. Victim impact statements exist to remind the court that crimes don't end with convictions. They echo for years, sometimes for life. The law recognizes a psychological trauma as real harm, equal to physical injury. When sentencing courts hear this, it directly informs a need for protection and deterrence. As a viewer, ask yourself, how does a justice system measure damage that can never truly be undone?
Ruin a little girl. And they would have had no idea. Fortunately, he was stopped before he could do.
This revelation is chilling. According to the state, even after the abuse ended, the defendant allegedly planned to continue harming the victim emotionally, using his own family as unwitting messengers. From a legal standpoint, this speaks directly to future dangerousness, one of the most important sentencing considerations. It suggests the harm was not impulsive, not isolated, and not over. Courts take this extremely seriously because sentencing isn't only about punishing the past, it's about preventing the next victim. Does this change how you view the argument that rehabilitation is possible here?
And that something can be wrong and can have consequences for others, even if you don't have somebody else telling you that it's wrong and forcing you to act in compliance with very basic human decency. There is no empathy in him. There is no sympathy in him. And unfortunately, Judge, you can't fix that. You can't rehabilitate that. And no matter what you do, you're not going to give that little girl back her sense of safety. The only thing that you can do is put him in a position where he can never hurt anyone else again. The defendant can't even claim that he had a rough upbringing or there was something in his childhood that caused him to do this. No, by all accounts, he had a great childhood, a stable family. No adverse childhood events to think of. His family did a wonderful job. And his parents are here, and they were here during the trial. And I'm sure they're sitting back there wondering, what did we do wrong? Did we cause this? And the truth is, it's not their fault. But they too are victims because all they can do is sit here and listen to what he's done and bear witness. Because I'm sure they don't condone what he's done, but he's their son. And no matter what, they love him. And finally, there's the other victim in this case, the victim's mother. The mother who entrusted her child to a man that she found at church, a man of God, a man that put himself in a position so that he could do things to her children. And she's sitting there feeling guilty and torn, wondering how she could have missed it. Wondering what she could do more to help her children. This isn't her fault either. She did her best with the options that she had, despite what the victim did, but despite what the defendant did to the victims. The only correct sentence here, Judge, is the absolute maximum term that can be delivered to him. That's all.
Thank you. Okay. Mr. Feldman, I'll hear from you and or your client.
Thank you, Your Honor. My client does not wish to address the court.
When the defense declines to have a defendant speak, that silence is legally significant. Allocution, the opportunity for defendant to address the court, can sometimes influence sentencing if it shows remorse or insight. Here, the court hears none. Instead, the focus shifts to appeal strategy. Judges notice that. Silence doesn't equal guilt. But in sentencing, it often reinforces conclusions already drawn from evidence and testimony, especially in a case where remorse has been questioned throughout. Would you have spoken if this were your last chance before sentencing?
AD. Additionally, the jury found that both victims were under the age of 12. Beyond that, the court finds additional aggravators of multiple victims in this matter. The court also finds the aggravator that the defendant was in a position of trust, i.e. providing child care for these victims.
This is where law overrides emotion. The judge carefully balances mitigators, family support and physical health, against overwhelming aggravators, multiple victims, victims under 12, and a position of trust as a caregiver. Under Arizona law, those aggravators trigger mandatory sentencing outcomes. Probation is not just inappropriate, it's legally unavailable. When the judge states that the statutory requirement is life, that's not opinion. That's a law being applied exactly as written. This moment underscores how juries, statutes, and sentencing rules converge into irreversible consequences. This case ends with one of the most severe sentences the justice system can impose: life in prison, with no possibility of release for at least 35 years. The court finds that the harm inflicted, the breach of trust, and the ongoing danger outweigh any mitigating factors presented. Restitution remains open, acknowledging that accountability extends beyond incarceration. This ruling reflects the system's primary duty in cases involving children: protection above all else. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts and comments, and subscribe for more in-depth courtroom breakdowns that examine not just what happens, but why it matters.